This is Wanjang, and I'm gonna talk about Islamic law and then the national legal development. Islamic law and then national law is different in the following features. Islamic law is derived from the universal nature, and it is applicable to all Muslims no matter their nationality or territory. However, national law is derived from the legal politics, and it is applicable only to a specific nation or territory. One of the examples of the national law is Indonesian national law. It is derived from the legal politics, which means in Indonesia, the national law outlined in the board outlines of the course of the nation and described in detail by the Ministry of Justice of the Republic of Indonesia. The national law of Indonesia applies only for Indonesian nationals and in Indonesian territory. According to experts Chief Justice Ali and Minister Ismail Saleh, the position of the Islamic law is like the followings. According to Justice Ali said, there are three components of the Indonesian legal system, which is traditional law, Western law, which is formal colonial laws, and Islamic law. There are three policies of national law developments. The first one is maintenance. The maintenance is to continue to maintain the structure of the existing legal system, even though such a system may longer be appropriate with the current system. It is to prevent legal vacuum, and it is logical consequences of the Article 2 of Constitutional Traditional Regulations. The second policy is transformation. It is to improve and refine the development of the national law, and it is to perfecting the existing laws and regulations to correspond with the new requirements in the relevant fields. And it is to complement any imperfection and perfecting the existing ones. The last policy is creation. It is to draft and establish new laws and regulations that have never existed before. For example, it's a creation of the new laws on the environment. The national law should serve and protect the whole nations and then the state in all aspects of existence. In Bahasa, it is wawasan kebangsaan, wawasan Nusantara, wawasan Bhinneka Tunggal Ika. By applying the three viewpoints in an integrated manner, the various norms of the Islamic law and then the traditional customary law would become an integral part of the national law. The first one, wawasan kebangsaan, the nationalistic viewpoint, it is two national law systems should be fully oriented toward aspirations and interests of the nation. And it has to reflect the legal aspirations, objectives, and functions of the legal system, and to maintain the character and ideas of the life as nation and the state of the Republic of Indonesia. And it is an open viewpoint that focused on the interest of the next generation and able to absorb the principles of the modern legal system. The second one, wawasan Nusantara, the archipelagic principle. It is to earn for the existence of the single national legal system, and it is to unify the legal system. It is for creation to conducive environment in all sectors to live under a single legal system. The last viewpoint, wawasan Bhinneka Tunggal Ika, can be translated in English, different but one. It is a viewpoint to consider of a specific need of a certain groups in a community so that all communities can receive just and fair treatment. It is to guarantee the inclusions of aspirations, values, and needs of the community into the national legal system. And it is to correspond or at least not to contradict the aspirations and the life of the nation and the state.
The position and status of Islamic law. Islamic law is accepted as one of the sources in the development of national law. Islamic law itself consists of two elements: ibadah, which is a worship or devotion to God, and muamalah, which is rules about all aspects of community life. Islamic law became an active source in the development of national law. It is to shape and maintain the social order of Muslims in Indonesia. These laws apply as long as Islamic law does not contradict the 1945 Constitution and specific legal needs of the Muslims. Even though the majority of Indonesians are Muslims, the norm of Islamic law does not automatically apply and automatically transform into national law. Such norms have to be in line and accommodate the needs of the entire Indonesian population. This is the same with traditional customary law and also the Western law.
The Islamic Law Review Team from the Badan Pembinaan Hukum Nasional or Babin Hukumnas has made the efforts to compile these norms and formulating their findings into something that could be used as a source for developing the national law. This team also invited scholars who were well versed in Islamic law from various schools of thoughts and doctrines, including ulama and other type of academicians to voice out their opinions of a specific issue within a scientific realm, which were specifically organized for that purpose. Besides the former, the team also invited scholars and ulama to conduct research and to write papers on Islamic law according to their expertise, field of expertise. Within this context, it may worth mentioning that since majority of Indonesians are Muslims, there are opinions that it was only appropriate that the norms of future national law should be based on Islamic law. Normatively speaking, uh, and as a consequence of having stated the two shahadat, the Muslims creeds there's no God but Allah and Muhammad is prophet, may seem appropriate to some. However, such a concept simply could not work when viewed from the perspective of political reality, from political interest of the country, from its legal politics. According